Right, good afternoon, everybody. We're just letting everybody in. Hopefully, people have been able to log on with no problems. My name's Nicola Twine. I'm joined by Tim Wilkinson. So thank you for joining us this afternoon. We're going to be talking to you today about employment issues and COVID-19. There's great uncertainty, as we're aware, as to how businesses are going to be reopening and getting the workforce back, and lots of questions that clients will have and we have about getting employees back in the workplace. Some of the issues that we'll be talking about have been hotly debated in the press: vaccinations, testing, employees refusing to return to work. But hopefully you'll find what we have to say and our considerations useful today. So I'm going to hand over to Tim to start off now.
Thanks, Nicola. Thanks, everyone, for joining us. We're going to discuss a few topics today, canter through those three that I've set up on the slide there. I'm going to look at vaccinations and mandatory vaccination policies, and then I'm going to hand over to Nicola to deal briefly with testing, and then on to returning employees and whether employees can refuse to return to the workforce. So in terms of vaccinations, you don't need me to tell you about the situation the country currently faces. We all know there's a vaccine rollout and it is progressing well. But of course, that doesn't mean that everybody is going to have the vaccine when offered it. We can see that the BBC recently published an article that suggested that in certain areas, up to 1/5 of people who have been offered have refused. And I read an article recently about concerning a survey of BAME people, and the take-up in those BAME groups was lower. It was 60% suggested that they would have the vaccine, which of course means that up to 40% haven't yet decided to do so. And we can see there that there's a prediction of up to 1/6 of people may refuse. So it's not a case, of course, that the vaccination is going to be offered and undertaken by everybody. And that, of course, is potentially going to have an impact upon the employment sphere. And employers are going to have to get to grips with it. And we are dealing with the age-old problem of individual autonomy as against the wider implications. Employers do, of course, have a responsibility and a duty to provide a safe working environment. They have to take steps to ensure that the health, safety and welfare of their employees is safe insofar as is reasonably practicable. The other aspect, of course, which employers need to consider is maintaining an efficient workforce. And that may require limiting absences insofar as reasonably possible in relation to COVID-19. So what is the legal position? Well, I hope no one needs me to tell them that an employer cannot force someone to have a vaccination. There is no express legal provision permitting employers to force a vaccination upon their employees. And even the government isn't attempting to make the vaccination mandatory at this stage. Indeed, the Public Health Control of Disease Act 1984 prevents them from doing so. There has been, certainly in the last few weeks, quite a bit of discussion in the media about whether the government is going to introduce a vaccination requirement for frontline health workers, but that isn't the same as enforcing vaccination. And what we can see there in the third bullet point, when we talk about vaccination policies and mandatory vaccination, what we really mean is the question as to whether an employer can deprive someone of a job by making that vaccine a requirement of the role. I suspect everybody on this webinar has read something about the no jab, no job. As Nicola highlighted, a number of the issues that we're talking about today are well versed already in the media and in legal commentary. No jab, no job features heavily. So can employers require a vaccination? We have to take this, look at this in a couple of different ways, because we have, on the one hand, new employees, applicants, and on the other hand, we have existing employees. The considerations may be largely the same for both groups, but there are obviously going to be some differences. If you are looking at new employees, it's going to be relatively simple to put into the contract a term requiring a vaccination. That's not so easy for employees who you currently have, which would involve, of course, a changing of their terms and conditions. So that's one of the differences, of course. Looking firstly at new recruits, as it sets out there in the first bullet point, there isn't any formal government guidance on this, certainly not that I've found and read. But again, many of you may have read about some employers who have already committed themselves to a no jab, no job policy, Pimlico Plumbers being one of them, perhaps the most infamous or famous of them, but they have been followed by the perhaps less well publicised Care UK and Barchester Healthcare. Now, as I say, it may be relatively straightforward to incorporate into a contract for new recruits that a vaccination is required, but that doesn't necessarily solve the issue, because introducing a mandatory vaccination policy can, in the right circumstances, be considered discriminatory. So I'm going to move on and talk about current employees, but we have to bear in mind that a lot of what I'm going to say about current employees also applies to new recruits and applicants. So existing employees, what is the legal foundation? How can employers approach this if you're advising employers? It's possible that there is an express term in the contract already. I suspect that's going to be extremely unusual. It seems very unlikely to me, but it's possible. Can an employer imply a term that deals specifically with COVID-19 vaccinations? Again, possibly, but there is a perhaps more straightforward route with the implied term that is already there. Is the requirement to have a vaccination a reasonable management instruction? Now, there's a lot of debate raging about this at the moment, and there are differing views. My view is that probably yes, in the right circumstances. Others may take a different view. But we have to, of course, I'm afraid, caveat this with a typical, perhaps, lawyer caveat, or perhaps a typical barrister caveat, that it depends upon the circumstances. None of this has been tested yet, of course, in the tribunals. And much remains to be seen as to how the tribunal, the judiciary, are going to deal with it. But with that caveat, then yes, in the right circumstances. So this webinar is about not necessarily giving you the right answer, but looking at how you might, when you're advising an employer, how you might approach the suggestion of a vaccination policy. And as an employee, when you're advising an employee, what is it that they're looking for from an employer? So employers in particular are going to have to get to grips with this. They're going to have to get to grips with vaccinations, what is on offer, what the risks and benefits are, and what each vaccination entails. And an employer is going to have to look at several things. The first bullet point there is arguably the most important, the working environment. So what is the need for interaction of these employees, be it with colleagues, be it with customers? What is the extent of their interaction? And playing into that, and part of that is, what is the employee's role? So we can look at a couple of different scenarios. The obvious one is a care worker, someone who works in a care home. The need for interaction is going to be greater than someone in an office, in all likelihood. That care worker is going to have to interact with colleagues, potentially when they're assisting someone else with a resident in a care home, and they are going to have to interact with the residents themselves, of course. But it's not just the level of the interaction, it's the nature. Care workers are likely to be far more hands-on and much less likely to be able to maintain, for example, social distancing. And of course, the nature of the client or the customer or the resident in a care home, for example, we're much more likely to find people who are in a more vulnerable category. So we can see already that there is going to be probably a distinction to be made between certain types of category of worker compared to others. I, for example, can do a lot of my work virtually from home now, or from chambers virtually. And even when I go to court, I can generally maintain social distance. So looking at the working environment is absolutely key. The nature and the size of the business might make a difference. An employer who has 1,000 employees may be better able to soak up a COVID-19 absence than a business who has only 20 integral workers. And so for them, limiting the COVID-19 absences may be of greater significance than the larger employer. One of the other options that might need considering, the second bullet point there, is there third-party pressure. Many of you may have read the recent tribunal case of Kubilius. I think Nicola might touch on that again in due course, but one of the issues in that case was the extent to which the customer required PPE and in particular face coverings. So has the employer got, or is the employer relying on a particular client, and is that client insisting upon vaccinations? That may well play a part in the decision to issue an instruction in relation to vaccinations. So we're looking at whether the need to protect others balances and to what extent outweighs the individual's rights. And to do that, as I say, employers and you, when you're advising your employees, are going to have to explain to them that they are going to have to do a deep dive on this. They're going to have to engage in a risk assessment. They're going to have to engage in the measures that they've taken, if they haven't already, and no doubt most people have, but the measures they've taken in relation to COVID-19 thus far. Are those measures sufficient? What is the reason why a vaccination is required in addition? But what other COVID-19 options are available that haven't yet been introduced? And as I've already discussed there in the fourth bullet point, it may be more reasonable an instruction for certain workers, such as care workers, than, for example, office workers. Now, the next slide is headed disciplinary action, but there's a stage before that, and perhaps I shouldn't say this as a litigator. It's perhaps a strange thing for me to say, but we can, when you're advising employers, you can speak to them about steps they can take to avoid the confrontation and the litigation that may flow from it. And this applies equally to whether if you're advising an employee, because you can be talking to the employee about the fact that resigning and claiming constructive dismissal may not be the first sensible step, because we're all in unprecedented times, and dialogue. As an employer can take steps to positively promote the benefits of the vaccine. Now, of course, promoting the vaccine, that's being done across the country in any event, but an employer may wish to take steps to promote within the working environment and focus it on the benefits, not only to that employee, but to their colleagues, their customers, particularly if they deal with particularly vulnerable customers. And part of that positive promotion might be countering negative publicity out there, of which there is, of course, a great deal. So an employer can be looking at what they need to do to discuss these issues, perhaps before they introduce any such policy, and certainly before they take any disciplinary action. An employer could speak with unions, representatives, even individual employees about what it is that they have concerns about and how those concerns may be addressed. They may have perfectly valid and sensible suggestions as to further steps that can be taken that fall short of vaccination, and it would do well for an employer to engage in those discussions and those suggestions, and equally from an employee's perspective, it would assist them if they can engage with the employer about what their concerns are and how an employer might address them. That taking those steps may not only limit the number of people who don't have the vaccine, but also might help avoid and certainly reduce the risk of constructive dismissal cases flowing from vaccination policies. But of course, if an employer introduces a mandatory vaccine policy, then there are likely to be situations where disciplinary action and possibly dismissal is required. Now, it's easy to get, we talk so much about COVID-19 at the moment, that it's easy to get bogged down in the COVID-19 situation and forget to take a step back and remember that any dismissal still has to be fair. We're still dealing with Section 94, Section 98 of the ERA. So when we're talking about disciplinary action and dismissal, we have to, of course, consider whether the management request, which is potentially leading to the dismissal, was reasonable in the first place. So that's the justification for the request, the reasonableness of it. And that's looking at all the things that we've just looked at and that I've just been talking about. What steps have been taken? What steps can be taken? But the employer is going to have to take probably careful and measured steps before getting to the dismissal stage. It's not going to be a quick fix in any of these scenarios, it seems to me. As well as considering whether the request was reasonable, what about other options that are available? If an employee is refusing to undertake a vaccination in the face of a vaccination requirement, what other options are available? Can that employee work from home? Many have been already, and many can continue to do so. But if they're in a role that they can't work from home and that all the reasonable COVID-19 steps have already been taken, what about the fact that they might be redeployable elsewhere? You may have someone, or an employer may have someone who works on a factory floor in a particular role that requires close contact with others. How about redeploying them in a different role on the factory floor where social distancing can be maintained, face coverings can be worn, screens can be put up? There are options. Or can that employee be redeployed into an office role where they can maintain distance and work in their own office, for example? So an employer is going to have to look at all those steps. If all those steps are undertaken and it is a reasonable management instruction, then once all those options are exhausted, then a dismissal may well be reasonable, likely to be for some other substantial reason. As an employee, of course, I've talked mainly about employers and advising employers, but as an employee, if you are facing disciplinary action, then there are these steps that the employer has to go through. The employee can be suggesting those to an employer, well, I can work here, or how about you redeploy me here, just to ensure that all steps are being taken that can be taken by the employer. Now, even if a dismissal is fair, that doesn't necessarily mean it's not discriminatory. The introduction of a vaccination, mandatory vaccination policy is in certain circumstances going to be considered discriminatory. Section 19 of the Equality Act is one example, indirect discrimination. And so employers are, as I said earlier, going to have to get to grips with the different vaccinations that are on offer and what is involved with those vaccinations to see how it impacts on their employees, and particularly those with protected characteristics. And we're likely to see certain characteristics come to the fore, and I've listed them there. Disability is likely to be one. Some people may have a medical condition that mandates that they don't undergo that vaccine. An employer may have pregnant workers. The current guidance from Public Health England is that there's insufficient evidence to warrant recommending the vaccine to women who are pregnant. So it's going to be somewhat more difficult to justify a policy in relation to pregnant workers if the vaccination isn't actually recommended. Religion and belief is another aspect. Some people may refuse on religious grounds, or perhaps because they hold a particular belief. I've given an example there of vegans who might, for example, refuse medical treatment because it involves animal products. Now, I'm not an expert. I don't think either of the COVID vaccinations that are being rolled out actually do contain animal product, but they may do. And this is the sort of detail that an employer is going to have to get to grips with if it rears its head with one of their employees. I've listed age there as well. This may not be an issue for too much longer, given the speed at which the vaccination is going to be rolled out. But it's clear that at the moment, the older candidates for a job or older employees are more likely to have been vaccinated, both first vaccination and the second vaccination, than the younger employees. So there may well be a situation where someone is disciplined because they haven't had a vaccination in their 20s. If they were in their 50s, they might have had it. Or an employee or a prospective candidate goes through the process, gets offered a job, and then it's discovered that they don't have the vaccine, and that offer is refused. It may well be refused because they haven't had the vaccine because they're in their 20s, and they would have done if they were in their 50s and 60s. So it has to be a consideration, certainly over the next few months. And finally there, I've listed anti-vaxxers. It's rather a global term that covers all multitude of those who don't wish to have a vaccine. But it's possible that anti-vaxxers, as they're termed in the media, might attract protection under the Equality Act because it is a belief. I've said there it's unlikely, but it is certainly possible. If we look at the Granger criteria, is it going to be an opinion or belief that is genuinely held? Yes, probably. But is it, looking at the second part of the criteria, is it going to be an opinion or a viewpoint as opposed to a belief? This may well be where most fall down, because reading about the vaccine and coming to an opinion that it isn't worth having is not the same as having a belief which attracts the protection of the Equality Act. Does it concern a weighty and substantial aspect of human life and behaviour? Probably. Does it maintain a certain level of cogency, cohesion, seriousness and importance? That very much depends on the circumstances. Of course, as I say, anti-vaxxers, that term covers a whole multitude. It may be that someone has a perfectly cogent belief and reason for that belief, but equally it may be that someone refuses because they think that it's part of a strategy for aliens introducing vaccines to the population. Who knows? There are a number of different options available, and whether it maintains a certain level of cogency, probably not in most circumstances, but possibly so. Is it worthy of respect in democratic society? Again, that will depend on the circumstances, and it may well be that one consideration is whether their views and their promotion of their views is potentially harming others. So those are the protected characteristics and the sort of things that employers are going to have to think about. But when we're considering vaccination policy and discrimination, the key issue is going to be justification. Can any prima facie discriminatory policy be justified? So is it a proportionate means of achieving a legitimate aim? And the legitimate aim is probably going to be relatively straightforward, as I've already touched upon. Health and safety and a safe working environment is a requirement of employers. It's potentially a criminal offence not to do so. So the legitimate aim, the health and safety of colleagues, customers, is likely to be relatively straightforward. Maintaining an efficient workforce may also be a legitimate aim, although perhaps not quite as strong an argument as the health and safety aspect, particularly in a situation where we don't yet know the extent to which vaccines lower or remove the transmittable, the rate of transmission in COVID-19. But the battleground is going to be proportionality. Is it a proportionate means of achieving that legitimate aim? And that depends on a myriad of factors, all of which, or probably all of which, certainly most of which we've considered in relation to reasonable management instruction. So why is it that the vaccination is required above and beyond the COVID-19 measures that have already been taken? And what other options are available? So those are all the things we're going to be thinking about when we're looking at and advising employers and employees. There's no straight answer, easy answer, and much of it remains to be seen in terms of how the tribunals are going to deal with it. But if an employer is going to introduce such a policy, hopefully those are good headlines for you and when you're advising as to what the considerations are and how to go about introducing that policy. And on that note, I'm going to pass over to Nicola.
Thank you, Tim. I'm picking up with testing first of all, which follows neatly on from vaccinations. Come as no surprise to you all that similar considerations arise with testing as they do vaccinations, and an employer cannot, of course, forcibly test any employee. Testing still invasive, but it's much less so than any vaccination. Justification for testing, because it's less invasive, is likely to be able to be demonstrably stronger than it is for vaccinations. Now, those who have secondary school children or children of that age will probably be aware that in secondary schools now, children are required or requested, not required, to take lateral flow tests twice a week and to submit those results ordinarily to the schools and to the NHS via the website. And that is so that there can be kept track and kept awareness of positive cases and measures put in place. And that's an instruction that generally comes from the school and is deemed to be a reasonable management instruction, or request, I should say, sorry, not an instruction, in most cases. Question is whether an employer can make it mandatory to have employees tested in their workplace. It is likely that in the right circumstances, certainly I would say, that they can have it to be a mandatory, or to have it as a management instruction. Question though is why in a particular case it is necessary. What are the other options available for protecting employees against COVID-19? it's imperative that if there's to be any particular instruction, that there has been perhaps consultation when considering the justification, but certainly there should be discussion, we would recommend, between employers and employees to make it clear why the policy is being introduced. Where there is a policy that's introduced, where an employer decides to have a situation whereby it says we want all our employees to carry out testing twice a week, and an employee refuses, how the employer responds to that is going to be, or how it wants to respond to that will have to depend very much on the circumstances in the individual case. An employer has to act reasonably in response to an employee who refuses to subject themselves to testing, and would be advised to consider each case on a case-by-case basis. To contemplate dismissing an employee or disciplining an employee, I should say, we don't jump to dismissal as the first course of action, but to contemplate disciplinary, there would have to be a breach in a particular case of a disciplinary rule, or a failure to comply with what we've deemed to be a reasonable management instruction. If there has been a breach or a failure to comply, it's not necessarily misconduct that would be sufficient to justify dismissal. It's important that the reason for the refusal is established, that it's considered, as is again the fairness and reasonableness of the instruction in the first place. And I'd take you back to the slide that Tim shared about disciplinary action. There'll be situations whereby it's possible, dismissal is possible, and you have to have consideration to other steps that might be taken, perhaps to avoid it in the circumstances, but it is something that an employer might be able to consider in the right circumstances. Moving on to deal with face coverings. Can an employer require employees to wear face coverings? Well, we know that you're required now by law to wear face coverings in certain places. They're not PPE in the sense that those that do personal injury will know PPE is personal protective equipment. They are face coverings principally to protect others. At the moment, guidance is that we must wear one in certain places, public transport, taxis, shops, indoor shopping centres, generally indoor premises where public come and go. And we're also expected to wear face coverings in indoor settings where social distancing may be difficult and we might come into contact with persons we don't normally meet. The government has produced some non-exhaustive guidance, a list of people who do not have to wear face coverings. They include persons who cannot put a face covering on or off easily because of a physical or mental impairment, children under the age of 11, persons for whom wearing a face covering might cause severe distress, and interestingly, also for people where exercising would negatively impact on their ability. And the guidance was updated on the 12th of March 21. And it's interesting to keep an eye on that, and employers might be advised to keep an eye on the government guidance of people who might be exempt, because that will have a bearing or could inform policies that they might want to make. So in certain circumstances, it might be a reasonable management instruction for an employer to say, we want our employees to all wear face coverings. Again, regard has to be had to considering what the justification is. To be a reasonable management instruction, there should be justification. It might be that employees have contact with members of the public, that you cannot in the particular workplace have a physical barrier between the employee and members of the public, or that the workplace is such where social distancing is difficult, such as on a line in a warehouse. So all those will inform whether the instruction is reasonable. An employer considering a policy of having face coverings must be aware, I've put as the fourth bullet point, of the possibility of discrimination. Again, an employee may have a disability that renders or prevents them from being unable to wear a face covering. So if there's a policy in place and they can't comply, the employer might face a Section 15 indirect discrimination claim or a Section 20 reasonable adjustment claim. If the employee might be subject to a detriment as a result of the instruction, the employer would have to justify the treatment as a proportionate means of achieving a legitimate aim. If a reasonable adjustment could be made so that the employee didn't have to wear a face covering, then any justification argument that the employer might want to raise would be unlikely to succeed. And in relation to face coverings, Tim touched upon the case of Kabilius, and that's one that some of you may have read about and have seen reported. I think it was either just before or just after Christmas. And that case makes some interesting reading when you're looking at the start of cases that are coming through at first instance related to COVID. In that case, we had a delivery driver who refused to comply with the request of a customer, Tate and Lyle, to wear a face covering when he was on the client's site. Client provided him with a face covering as he entered the site in his van and requested that he wear it. He said he didn't need to because he was in the cab, and as far as he was concerned, the guidance didn't require all workers to wear face coverings. Client repeated the instruction, or request I should say, on a number of occasions whilst the claimant employee was on the site, and he refused still. Outcome was that the customer, Tate and Lyle, said, we don't want that delivery driver back again, we're banning him from the site. It was a requirement of the Mr. Kabilius's company handbook, his employer's handbook, that he be courteous to customers, clients, and comply with their reasonable requests. It was, employer said you haven't done so, and dismissed him, finding that he hadn't shown any remorse for his refusal and his actions in response to the request. And the case was found against, or he claimed failed for unfair dismissal. It was found that Mr. Kabilius, his employer, had a genuine belief that he was guilty of misconduct, and that dismissal within the range of reasonable responses. It's important to be aware in looking at cases like that they are very, very fact sensitive. They might offer some indication of how tribunals in certain areas might find, but in that case, dismissal with it was perhaps found within a range of reasonable responses, not just because he had refused to wear it, but also because there was the company handbook that said you have to adhere to customer requests, and there were a number of factors which perhaps went against Mr. Kabilius. So moving on to deal with health and safety. Refusing to return to work. This is something that some employers may be faced with. Of course, many persons in society at the moment are concerned about perhaps going further beyond their homes, how returning to what we might call normal life will affect them, and returning to a workplace. Concerns are likely to remain very live for a long time. Employers face the prospect of employees saying, I'm not coming back to work, or going back to work, and then saying, I don't feel safe, and going home. Question arises whether an employee can refuse to return to work. Short answer is yes, but only in certain circumstances, in the right circumstances. And we refer on this slide to Section 44 of the Employment Rights Act and Section 100. Section 44 is the right of an employee not to be subject to a detriment for not attending the workplace if they have reasonable belief of serious and imminent danger, and that is a danger which the employee could not reasonably have expected to avert. Now I say employee, but it's important to be aware, and that this doesn't appear on the slide, but at the moment there is a statutory instrument in draft form that is extending section 44 detriment protection beyond employees to workers. And that's likely to be approved, and it is to come into effect and apply to detriments taking place after, not before, the 31st of May 21. So from the 31st of May, it is anticipated that section 44 protection will apply to workers as well as employees. The section 100 protection is concerns automatic unfair dismissal, where dismissal is for an employee not attending work and their belief is, or they had a reasonable belief of serious and imminent danger which prevented them from attending work. It's important to be aware that under that section, damages are uncapped and there isn't a need for a qualifying period. So we can envisage employees who couldn't otherwise claim unfair dismissal, perhaps trying to bring claims in via section 100. So considering health and safety aspects, section 44, section 100, the first question is reasonable belief, serious and imminent danger. It's important to be aware at the outset that the burden here rests on the employee to show circumstances of danger which they reasonably believed to be serious and imminent. And it's the belief of the employee that is important. It doesn't matter whether the belief transpires to be accurate or not, whether there were in fact circumstances of danger. That is not the test. And I refer to the case of Odahar and Esporta, where the court dealt with that point, the EAT dealt with that point. In that case, the claimant was dismissed for refusing to mop an area on a premises where there were protruding wires, and they were concerned for their health and safety and said, I'm not doing that, I'm not going to work. The employer said, we don't agree that the wires are in any way unsafe. And the EAT held in that case that it isn't relevant what the employer considers. It's the belief of the employee, they stressed, that is important. In terms of danger, currently it's untested in the circumstances of COVID-19, but it's likely to be widely interpreted. A case that illustrates this and makes the point clear is that of Harvest, Preston, McCaffrey. It doesn't appear on the slide, but it's a 1999 case, IRLR 778. In that case, it was stated that the word danger is used without limitation, and Parliament is likely to have intended those words to cover danger, however originating. Relevant to consideration of COVID-19 as a danger, the health protection coronavirus restrictions regulations, which appear at the bottom of this slide, and the fact that they explicitly state they were made in response to serious and imminent threat to public health. That is something that employee might point to. The main issue is likely to be whether the employee had a reasonable belief the danger that they identify is serious and imminent. Now, the seriousness of COVID-19 is clear to everybody. Question is whether the risk in the particular case is serious. Again, this is going to be fact sensitive. It depends on the steps that might have been taken in the workplace. Whether there is a reasonable belief that danger is serious and imminent is informed by whether the employer perhaps has performed a comprehensive risk assessment, whether suitable steps have been taken in response to that risk assessment to make the working environment COVID secure. Does the employer have a vaccination or testing policy? What are the individual circumstances? Those are all questions that might inform a consideration as to whether the employee's belief of danger is a reasonable belief. it is more likely that a claimant employee will reach the threshold of establishing that they had a reasonable belief a danger was serious and imminent in a case where perhaps government guidance hasn't been followed, or where an employer doesn't have a risk assessment, or at least one that they haven't shared with the employee. They haven't taken steps to ensure social distancing is implemented. So those are all factors to be aware of. We do recognise, as I set out on the third bullet point, that it's unlikely an environment, a working environment, can be entirely risk-free. And we stress that the employer has to take sensible steps. In terms of the threat that poses or presents an employee, the question is whether it is imminent. Potential danger is not imminent, but the threat that the employee might be concerned about doesn't necessarily have to be to themselves. It could be threat of serious and imminent danger to another. So there might be a potential situation whereby an employee is refusing to attend the workplace, perhaps for fear of returning home because of the measures that are not in place in the workplace. They might be fearful of infecting vulnerable members of their family, so seek to rely on Section 44 or Section 100. A case whereby it was consideration was given to threat to others is that of Mistake and City Restaurants 1999 IRLR case. And in that case, it's very different on the facts, but it shows the extension of the relevant parts. In that case, the claimant was a cook, refused to cook chicken that hadn't properly been thawed out, because not he was concerned about himself, he wasn't concerned about other employees, but he was concerned about those who would then have the chicken fed to them. At first instance, the ET said that they couldn't rely on Section 100 as danger wasn't to himself or other employees, and the EAT disagreed. So that's one perhaps to be aware of. Now, these cases, or it'll be a while before, as I say, these cases likely, or they start coming through the tribunals. But there's a case that was decided a couple of months ago that makes some interesting reading, as well as the Cabilius case. That's Rogers and Leeds laser cutting that was heard in Leeds Tribunal at the end of January. And that's relevant to health and safety dismissal. In that case, there was a warehouse setting. The incidents with which the tribunal were concerned occurred at the very beginning of COVID-19 affecting workplaces in March 2020. Claimant's colleague started showing symptoms of COVID-19 in mid-March and was sent home. The workplace, Leeds Laser Cutting, had conducted risk assessments. They had implemented measures to protect their employees. They sensibly had a system of staggered starts for all employees in the warehouse, so people weren't coming and going at the same time. Had social distancing in place, well able to be carried out in the warehouse. Face coverings were requested to be worn, and they had hand washing facilities. The claimant himself was concerned, he said, because he had a vulnerable child and a baby, and he didn't know how COVID-19 might affect the baby and was concerned about his child. On the 29th of March, the claimant sent his employer a message saying, "I'm going to be staying off work until lockdown eases." He didn't raise any concerns about the particular workplace. He didn't get back in contact with his employer. He just stayed off work. Sometime later, in April, he was dismissed. He brought a claim for unfair dismissal, relying on Section 100, saying that there's serious and imminent danger to me if I go into the workplace, and he was claiming that his dismissal was automatically unfair. Again, it's fact sensitive, but it makes interesting reading. The tribunal dismissed his claim as they found his decision to stay off was not directly linked to the working conditions. There was no indication in his communications that it was, whilst that was his case before the tribunal. Tribunal found that his decision to stay off work, not to return to work, was due to concerns about the virus COVID-19 generally. He hadn't demonstrated a reasonable belief that danger is serious and imminent. And that may well be the case of some cases, many cases that we come to consider in the future. So I'll put the name of that case after I finish, perhaps in the chat box, so you can look it up in your own time. So carrying on and health and safety and refusal to return to work, stress on this next bullet point that it's about the employee's belief. As I say, don't forget that. Dialogue again is key. An employer has to ensure that they fully explain what steps they've taken and why, so to perhaps prevent employees from going off, not coming in, or to make them feel comfortable coming into the workplace. Where there is communication and where there should be communication, where employees have suggestions about the workplace, improving the workplace, what might make them feel more comfortable, how they perceive the workplace might be more secure. Those suggestions should be taken seriously, and we would recommend responded to. Question arises to succeed in a claim, whether under section 44, section 100, whether the employee could not reasonably been expected to avert the danger himself. Where an employee refuses to return to work to have protection, the circumstances must be such that they couldn't reasonably be expected to have averted the danger. Now, any tribunal is not likely to be sympathetic to a claimant who refuses to attend work when the means of ameliorating the circumstance of danger are within their power, perhaps by adhering to social distancing, hand washing, coming in at different times. In the context of COVID-19, whether an employer has the means to avert danger themselves is again likely to be very fact sensitive. It's unlikely that an employee who cannot work from home and whose employer is following the government guidance would perhaps be justified in refusing to return to work without having explored with their employer ways that might make them feel safe in carrying out their role. So this comes back to dialogue. One question following on from an employee who's refusing to go return to work is whether that employee should be paid or not paid for the time that they are not at work. And the question here is detriment versus whether they're ready, willing and able to go to work. You may well have seen on legal commentary over the past few months that there are varying legal views on this. We do need a test case, and I have no doubt that that will come in time. In argument often advanced in support of the employee being paid is that section 44 itself is intended to be protective. It states that an employee will not be subject to detriment. But argument against is that in order to be entitled to payment, you have to, under the Employment Right Act, satisfy the basic condition: you are ready, willing and able to work. It's foreseeable that in some situations employers might not be inclined to pay. They might be prepared to take the risk that they'll have to pay back at some point in the future. So if you're acting for any employees seeking to rely on section 44 who might be concerned about payment and not being paid whilst they are refusing to go to work, what would be recommended is that they offer to change their work, perhaps to a temporary role that might be done from home or some other type of work. Just certainly take some action to show that they are willing and able in order to address arguments that the respondents might raise themselves. So, bringing things together, in conclusion, what we have, what we stress, the one word you've commonly seen across many of the slides is that of dialogue. Important that it's two-way discussions and listening to employees by employers. Employers need to ensure that they communicate to employees risk assessments, measures, whatever new systems are implemented to control risk of COVID-19. Absent communication, it's easier and will be easier for an employee to assert perhaps that they were justified in perceiving a risk of serious and imminent danger. Employers would be advised to listen to concerns about returning to work, face coverings, testing, vaccinations. Employers advised to follow government guidance to ensure that they're aware of updated guidance at all times and they react accordingly to it. And in terms of management instructions, whether it be for face coverings, testings, vaccinations, recommendation would be at all times that employers carefully word those instructions, that they ensure they're justified and communicated. And when I say communicated, it isn't just the instruction itself that ought to be communicated, it's the rationale, the justification, so that the employee knows why. Come as no surprise to recognise that failure of an employer to engage in dialogue, follow government guidance, ensure that they are justified in their policies that they seek to introduce will likely lead to employees raising grievances, claims for constructive unfair dismissal, discrimination, and claims testing the boundaries of Section 44 and Section 100. They're likely to follow in any event, but they're likely to have more merit in circumstances whereby there isn't dialogue, there isn't following of guidance, and there isn't instructions that are reasonable. So those are the points that we would perhaps highlight. Thank you for your time today. We've had a good number of participants, so I hope you found what we've had to say interesting. Now, we haven't provided a handout, but we can make our PowerPoint from today available for those who would like it. So might I suggest that you drop your name in the chat box and we can arrange that that is sent to you if you would like the PowerPoint notes available.